Hello everyone. Today we're going to talk about a very important USCIS memo that affects people applying for a green card from inside the US. You may know that I've already legally analyzed this memo in my previous video. What I'm going to do in this video is try to give you more insight as to what the memo means, how you can prepare for the green card interviews, and what my experience is after the May 22nd memo. I will tell you my experience at the actual USCIS interviews that I went in various parts of the US. This AOS memo was published on May 22nd, 2026, and it signals a new period of increased caution, especially for Form 485 adjustment of status applications. Adjustment of status means applying for a green card from inside the US without leaving the country. For this reason, this topic is very important for people who are planning to apply for a green card, those who already have a pending 485 case, and those who will attend a green card interview in the near future. It is suffice to say that there's a lot of confusion about this memo. That is why my goal today is to explain the issue as clearly and practically as possible. I will also share some observations from my recent green card interviews that I have attended. We will discuss what USCIS is looking at when evaluating these cases, which factors may be viewed positively or negatively, and what documents should be prepared before attending an interview. Let's begin. First, let's clarify what this memo actually says. With this memo published on May 22nd, USCIS emphasized that adjustment of status, meaning applying for a green card from inside the US, is not an automatic right. So in other words, even if a person appears to be technically eligible for Form I-485, that alone does not necessarily mean the application must be approved. A USCIS officer may not only look at questions such as, does the person have an eligible I-130 or an I-140 petition? Is the priority date current? Did the person enter the US lawfully? Does the person meet the basic eligibility requirements? These questions are still very important. However, with this memo, USCIS officers are expected to evaluate the case as a whole. This is called totality of the circumstances. In other words, the officers may now ask, is this person only technically eligible to receive a green card from inside the US, or should this case be approved as a favorable exercise of discretion? This is where the magic word discretion comes into play. USCIS treats adjustment of status not as an automatic replacement for constant processing, but as an exceptional option that may be approved through the officer's favorable exercise of discretion. For this reason, after this memo, I-485 cases may require more than just basic forms and standard documents. Evidence showing the positive aspects of the case may become more important. The key message from USCIS is this: people applying for 485 should no longer ask only, am I eligible? They should also ask, what documents in my case support USCIS using favorable discretion to approve the 485? So what are some of the situations USCIS consider as negative factors? A USCIS officer may look not only at the applicant's current situation, but also at the applicant's prior immigration history. Negative factors may include the person previously violated their status, the person worked in the US without authorization, the person overstayed the period of authorized stay, the person failed to comply with the terms of their visa or status, the person previously gave incorrect information to USCIS, a consulate, CBP, or another government agency. There are inconsistent statements in applications or interviews. The person has arrest, citation, criminal charge, court records, or serious legal issues. There are issues with tax filings, or the person's work history does not match their tax records. The person came to the US with a temporary visa, but USCIS believes the person may have intended from the beginning to live permanently in the US. This last issue is especially important for people who entered the US on a B1, B2 visitor visa, F1 student visa, or another temporary status and later applied for a green card. The important point is this: not every status violation or negative factor automatically means a denial. However, if these issues exist in the case, they must be analyzed in advance and, when necessary, supported with documents and explanations. Trying to hide a problem that USCIS may already see or pretending that it doesn't exist can create serious risk. What are the positive factors USCIS is considering when using favorable discretion to approve the adjustment of status application. It may not enough to simply say there is no problem in my case. The applicant should also show why the case deserves approval as a favorable exercise of discretion. So positive factors may include close family ties in the US, such as US citizen or green card holder spouse, child, or parent. The person has lived in the US for a long time. The person has maintained lawful status. The person has a regular and lawful employment history. Taxes have been properly filed and paid. The person is financially self-sufficient. Educational background, professional achievements or area of expertise, contributions to the US economy or society, volunteer work, community service, professional memberships or reference letters, a clean criminal record, general compliance with immigration laws, hardship that US citizen or green card holder family members may suffer if the application is denied, health issues, children's education, family caregiving responsibilities, or similar humanitarian reasons. Practically speaking, the positive factors in a 485 case should not only be described, they should be supported with documents, and that's very important. For example, instead of simply saying I support my family, it is better to show this through financial records, medical records, school records, or household evidence. Instead of simply saying I maintain my lawful status, it is better to show this through I-94 records, approval notices, I-20s, transcripts, pay stubs, W-2s, and similar documents. So after this memo, document preparation becomes even more important. Every case is different, so not everyone needs to prepare the exact same documents. However, preparing documents showing positive factors is very important. These include documents showing lawful entry into the US, documents showing maintenance of status, documents showing lawful employment and tax compliance, documents showing family ties in the US, documents showing hardship or humanitarian reasons if the person leaves the US, documents supporting good moral character and a clean record, and if there's any criminal issue, court disposition documents must be prepared. Simply saying the case was dismissed may not be enough. USCIS usually wants to see official court records. And if there was any prior status violation, overstay, unauthorized employment, these issues should be carefully reviewed before the case is filed or before the interview. The purpose of these documents is not only to complete the form. The purpose is to show to the USCIS officer that the case overall deserves a favorable exercise of discretion. So which applications does this memo actually affect? It actually affects a lot of things. All family-based cases, all employment-based cases, asylum-based adjustment of status applications, DV lottery cases. All the cases that can be approved by USCIS discretion is affected by this memo. So here are some of the questions the USCIS officer can ask during the interview. Why did you apply for adjustment of status instead of applying for consular processing? Are there any factors preventing you from processing the case at the consulate? Why did you remain in the US after your non-immigrant status has expired? What family or other ties do you have in the US? These 4 general questions kind of show how the USCIS officer can approach this case to understand whether, according to the totality of the circumstances, this case should be approved as an adjustment of status. Before going into my own experience in the adjustment of status interviews that I've attended since the May 22nd memo, I want to point out 2 things. First of all, the dual intent visas. H-1B and L-1 visa holders are asking me if they are affected. The answer is they may be, because the memo specifically acknowledges these 2 dual intent visas, but says that just because you have maintained your status in these visas, that doesn't mean that you can adjust in the United States. I think this is where the memo goes a little bit too far, and I think H-1Bs and L-1Bs are going to be fine in the adjustment of status interviews, but we will wait and we will see. The second thing is change of status and adjustment of status are 2 different things, and this memo only affects adjustment of status. If you're filing for a change of status from one non-immigrant visa status to another non-immigrant visa status. Let's say you're filing a change of status application from B2 tourist to F1 student. Let's say you're filing a change of status from F1 student to H-1B professional worker visa. Then this memo doesn't affect you. It has no application in the non-immigrant visa change of status applications. So let's not confuse adjustment of status and change of status. What we're talking about is adjustment of status applying for a green card within the US. Okay, let's come to the fun part. My experience in 485 interviews after the May 22nd memo. I've been to interviews all over the US. I've been to Boston, I've been to Nebraska, I've been to Orlando, New York, New Jersey. I've heard about a case in California and Virginia, so I think I can give you a pretty good idea as to how things are after the May 22nd memo. Here's the general theme. Since USCIS does not have any clarification as to how this memo will be applied, the officers are very confused and they are very concerned. On the one hand, they want to apply the law and they don't want to lose their job. But on the other hand, there's this memo that changes a huge thing in the immigration but doesn't say anything about how this will be applied. So they are very confused. In some of the interviews that I have attended, immigration officers specifically told me that they're not going to be dealing with this memo in this interview because they don't know what to do about it. In some instances, we have prepared a letter, documents showing good factors, that there is no negative factors. They refuse to take those letters and documents, saying that they don't know how to evaluate that unless there's a clarification from USCIS. There was an officer who told me that he started asking the new adjustment of status memo questions about why you applied in the US, why you didn't apply at the consulate, and then he started not asking them because he didn't know what to do with them. There was another officer who told me that he first got an instruction saying that this memo will affect the family-based applications and not so much the employment-based applications. But then he said, I've gotten confusing signals. We don't know what this memo will apply to. He also refused to take any documents showing positive factors under the adjustment of status memo. I've talked with another officer during an interview who told me that things are taking way longer than it used to and that he was feeling bad, that people were waiting in the waiting room for hours for interviews. He also told me that he's going to ask the adjustment of status questions because he was told to ask those questions, but that the answers to those questions will not affect his decision. Well, that's a very interesting approach. So he's trying to keep his job, so he's going to ask those 3 questions, but that is not going to factor into his decision because, he said, he already believes that the marriage is real and the person can stay in the US because she did everything according to the rules. So that kind of shows you what a difficult situation the officers are in at the moment. But they want to keep their job, but at the same time, they don't feel comfortable with this new memo, which imposes a lot of new duties to these officers without giving any outlines as to how they can accomplish them. Yes, they are being told they have to do it, but how are they going to implement it? There is no guidance. I've only seen one denial based on this adjustment of status memo right now. It wasn't my case. It was a case out of Virginia. But one disclaimer, Virginia office is known to be very tough, very meticulous about the 485 applications. So seeing the first denial out of Virginia office didn't shock me at all. But we have to analyze the facts here. The facts were the person entered the US on an F1 visa. He started working immediately after his entry, thereby violating his status. 4 or 5 years later, he got married to a US citizen, filed for adjustment. During the interview, when he was asked if there were any specific reasons preventing him from going back to his home country, he said no. When he was asked, are there any specific reasons why you're filing for adjustment status in the US, he said no. So he wasn't very well prepared to that interview. That's what I saw on the denial decision, that he didn't have very good preparation, very good documentation during this interview. And there was adverse factors such as coming to the US on an F1 and starting working immediately after coming to the US in the same month. And USCIS knew about this because this person came to the US on an F1 visa, started working immediately after they came. So that kind of shows you maybe he had preconceived intent to come to the US on an F1 and start working immediately. That's another thing. Up until now, working without authorization was not a problem when you get married to a US citizen, but it seems like this may be a problem, especially if you started working immediately after you came to the US. So that maybe that's something we can take out from that denial. Now, I want to tell you that's the only denial decision that I've heard about the adjustment of status application. That doesn't mean there is no other denials out there. I just didn't hear about them. But generally speaking, the officers seem to be very confused. Most of them told me that they're not going to apply this memo for their decision. And some of them told me that they were going to ask the questions, but that the answers to those questions will not affect their decisions. So this is in a nutshell my take on the adjustment of status memo and my experience about it. I know it's very confusing. We're going to keep you updated with all of this. I usually share my experiences in my Instagram channel as well. I will try to do that, and I will try to shoot another video when more cases come up. I hope this video is helpful. If you have any questions, you can send me in the comment section below, and I will try to Bye.